Sir, let me.
Madam, am I audible? Hello, madam. Unmuted. Hello, am I audible?
Yes, sir, you are.
Okay, so when we can start?
Good morning, sir.
Yeah.
Sir, actually, we would start in a couple of minutes. We would start
Okay.
at sharp 11. So let everyone join in, and we would start in like 2-3 minutes, sir.
Okay. Okay.
I request all the participants to please. We would start with the meeting in a couple of minutes.
हे unmute कर. Mute. मला तिकडे विचारूया ऐकू आलं कारण. अकरे वाजले. सगळ्यात निहारला संशय 11:50 11:38 11:40
A very good morning to all of you. I think so. Yes, okay. A very good morning to all of you. I welcome all of you to the 3-day lecture series titled Azaadika Amrutmahotsav, where we are going to talk about various topics, and we have invited very esteemed speakers for the same. I welcome you wholeheartedly in this pandemic situation for the same. And to officially inaugurate the lecture series, now I would like to invite our principal, Dr. Sunita Ada ma'am, to please address the participants. Ma'am, over to you.
Thank you, Akshay Ogle sir. Very good morning to all of you. Am I audible? Yes, can you hear me?
Yes, ma'am.
Yes. Okay. Very good morning to all of you. Myself, Dr. Sunita Ada, Principal of Modern Law College, Pune, welcome you for this 3 days lecture series on Azaadika Amrutmahotsav. And this is being organized by Students Development Cell and NSS unit of Progressive Education Society's Modern Law College, and it is in association with Board of Students Development, SPPU. Every year, college is organizing various activities, and these activities are in association with Savitribai Phule Pune University. It is like national level and state level seminars under quality improvement program, Shankar Rao Kanitkar national level moot court competition, Duff Current Duff state level street play competition, and it is always in association with Board of Students Development, SPPU. I would like to introduce to all of you about our Progressive Education Society and about Modern Law College. Progressive Education Society is a reputed and it is a distinguished educational institute in Maharashtra. It was started by late Sri Shankar Rao Kanitkar along with his selfless dedicated team of 5 teachers known for their highest moral values. And they laid the foundation of the society, which was on 16th of May 1934 in Pune. It was an auspicious day of Akshay Tritiya. And I proudly feel to tell that Progressive Education Society is only 87 years old society with the noble path and principles they are following. There are 2 remarkable words that appears in the name of the society, and its educational institutions are progressive and modern. The inclusion of these 2 words are certainly with some noble intentions, which serves as a guiding principle for Progressive Education Society, and they are to be followed with determination. Progressive is nothing but keeping with the spirit of time and innovation, while modern means modern in outlook, up to date in all matters, whether it is in academics or sports or any other cultural activities also. It is resolved to use modern equipment and also modern techniques to reach the students. The aims and objectives of Progressive Education Society, as laid down in its constitution, are to impart generally to the rising generation of this country and particularly to the resident of Maharashtra and efficient pre-primary, primary, secondary, higher secondary, and college education, embodying a literacy, scientific, technical, commercial, and also industrial training and training of teachers also by establishment of the institutions at Pune and other places in Maharashtra. Progressive Education Society, as on today, is providing education to more than 52,000 students, and there are more than 3,500 people who are employed under the umbrella of Progressive Education Society, and it is providing education right from KG to PG and also research center. Progressive Education Society's Model Law College was established in the year 2003, and it is one of the premier legal educational institute in Maharashtra, which is situated exactly opposite to Savitribai Phule Pune University in Pune. The college, though it is in the infant stage, but has carved a niche for itself. I proudly tell you that our college is permanently affiliated to Savitribai Phule Pune University. It is recognized by Bar Council of India, and also it is recognized under section 2F and 12B of UGC Act, and it is accredited by NAC with B++ with CGPA of 2.84 by NAC Bangalore. The college stands as one of the best law college in Pune. All the courses like 3-year course, 5-year DLLB course, LLM course, various diplomas, all these are being recognized by Savitribai Phule Pune University. And I'm glad to tell you that this year Progressive Education Society has also been recognized as a PhD research center under the umbrella of Savitribai Phule Pune University. The academic excellence of the college is manifested from the results of the students of Peace Society's Modern Law College, which is not only in academics, but also in curricular, extracurricular, and also sports activity. Students have really won laurels for the college in various state and national level competition. Coming to today's lecture series program, Azaadika Amrutmahotsav is a series of events to celebrate 75th anniversary of India's independence. The Mahotsav has launched 75 weeks, which started, this program has been started before 15th of August 2020, and this will continue till 15th of August 2023. We Indians are proud of our constitution and a democratic setup. We have also proved ourselves with our hard work, both at national level and also at international level. Constitution of India has laid down the framework defining fundamental political principles. It has also established structures, procedures, powers, duties of government institution, and also it has set out the fundamental rights, directive principles, and also duties of the citizen. Constitution sets out the various ways in which those who exercise the powers may be held accountable to the people they serve. But at the same time, it sets out the governmental powers end, that is by guaranteeing individual specific rights and freedom. These rights helps us to achieve, it helps to assure the protection and promotion of human dignity, equality, and also liberty. Indian Constitution has laid down the national goals such as democracy, secularism, socialism, and also national integration. Now, our Constitution is 70 years old, and since its commencement till date, it has not only drastically protected the rights of people, but also the ambit of right has been expanded and it has provided the maximum benefits to the masses. It is very interesting to study Constitution in different perspectives. And also, it is with this purpose we are organizing this lecture series. All our resource persons for this lecture series are, we have different dignitaries. First, we have Paramjit Jaswal sir, who is a Vice Chancellor. We also have Sanjay Jain sir. He is a principal, in charge principal of ILS Law College. And we have Sheila Barse madam, who is a social worker. Advocate Uday Varunjikar, practicing lawyer at Bombay High Court, Dr. Pratap Sarunke, who is an associate professor at Army Law College, and we also have Vikramaditya Rathod, who is a research scholar at SPPU. We are fortunate to have all these eminent personalities and these dignitaries with us. It is just a feast to listen to them and enrich our knowledge. So I urge to all of you to listen to this lecture series for 3 days. And once again, I welcome all of you on behalf of Modern Law College. And I in person take this opportunity to welcome all of you for this lecture series. Thank you so much. Over to Akshay sir.
Thank you, ma'am. I would like to take this opportunity to introduce the speaker for our first session, Professor Dr. Sanjay Jain, Additional Charge, Principal of Indian Law Society's Law College, Pune. Sir has completed his PhD focusing on feminist critique of judicial process in India and has done a diploma in mental health law from Central European University, Hungary, along with participation in Summer School of on Disability Rights in National University, Ireland. Sir has 22 years of experience as a faculty of law, having expertise in comparative constitutional law, administrative law, jurisprudence, international economic law, feminism. In 2004, Sir has received the President Award for Most Efficient Disabled Employee at the hands of Dr. APJ Abdul Kalam. Sir has co-authored and co-edited the book Basic Structure Constitutionalism, Revisiting Keshwanand Bharati. Sir has participated in 15 international, 45 national, 47 state, and 30 university or local level conferences, seminars, and workshops, and presented more than 50 papers on contemporary legal and social issues. Sir has experience in policy framing and legislative drafting at both state and national levels. Sir has 7 honors and awards and 23 publications to his name. Sir is associated with 3 renowned organizations, the Tata Institute of Social Sciences, International Constitutional Law Society, and the Maharashtra Knowledge Corporation Limited. Presently, Sir teaches the courses on constitutional law and comparative constitutional law. Sir is a true inspiration for all. I would now request Sir to take over the session and give his insights on the topic, reservations, new debates, and new answers, if any.
Thank you very much. Let me first congratulate Anna Madam for getting her PhD center and letting us know about the wonderful society and the law college, which she is very ably heading. I'm also happy to learn that this lecture series is part of the Amrutmahotsav of Azadi, right? And although it is very paradoxical, do we really have to have a Mahotsav of Azadi in independent India, right? Independence must be seamless, right? And every day must be Mahotsav of independence. But as they say, festivity adds to the happiness, and festivity is the part of Indian culture. So even our Prime Minister talks having a Mahotsav of vaccination. So Mahotsav is important to bring in energy. Mahotsav is not only about, fanfare or doing fat things, but I think Mahotsav is something which brings energy in us. It motivates us. It's kind of a cherry on the cake. It's a motivation pill. Coming to the are really new debates around reservations, and if there are any new questions, and if at all new questions, there are any new answers. Very interesting topic. I often wonder when reservation, talking about reservation is touching nest, because it cuts both ways. As an academic, one should never be afraid of facing the fire test, because as you have to train on either side of the course, right? Either side of the arguments must be by you to your pupil. And that's what I believe, and that's what my teacher, Dr. Deshpande, believed. He used to say, he used to always memorably tell all of us that as you grow, keep yourself grounded, keep your head high. And he said the benefit of remaining grounded is no one can push you down. But the disadvantage of trying high sky is that people can push you down, and then you can be even killed while coming down. So rather than getting killed in an obsession to reach heights, better to hold one's head high and yet keep one's feet grounded. And that is what is all about reservation, right? What is reservation after all? Reservation implies that every citizen of this country must be able to hold himself on ground. Every citizen must be able to get kind of play he deserves in our society. Now, deserve or desert does not mean that somebody else will decide what I deserve, right? Deserve or desert means according to my qualifications, according to my status. Again, the status is not socially determined. Status is constitutionally determined. What I am entitled to. And when we talk like this, then it becomes clear that our certain entitlements are embodied in all of us. They are categorical entitlements, like equal treatment, like enjoyment of certain freedoms, freedom against exploitation, right to celebrate one's own culture, right to take pride in one's status. So these are all aspects which are unquestionably categorical, and along with these credentials, as a citizen, whatever I am due to, I must be able to get. That is what is the commitment of our constitution to the people of India. In fact, Justice Chandrachud very well said that Indian constitution is transformative in nature, right? It is not. It is not something made up of patchwork of provisions across from the constitutions across the world. It may look like patchwork of provisions from constitutions across the world if you read it superficially, but upon a closer inspection, upon uh, introspection, uh, one realizes that Indian constitution is more than regulating the relationship between the various organs of the state. It is more than regulating the relationship of organs of states and uh, citizens inter se. It is more than even creating new organic election commission of India. Indian constitution, in fact, is about bringing emancipation. It is an emancipatory document, right? Now, Karl Marx used to say very interestingly that for every emancipatory provision in constitution, there is a repressive provision. Now, and that was his critique of capitalist law. And if you take our own constitution, if there is a emancipatory provision by way of Article 21 or right to equality, there is a repressive provision by way of 9th schedule, which allows the state to keep all constitution violating laws in the shell and provide immunity to such laws against judicial review. So, amidst crossfire of repression and emancipation in a constitution, how to survive? Particularly when the society is uneven, particularly when the society is diverse, particularly when the assets of the public good or the public goods are not equitably distributed amongst the citizens. That is a question. And when this question came before our great man, the son of the side, Dr. Ambedkar, he immediately reacted saying, okay, look, constitution may be the top dressing. Just like we prepare salad and over salad you spray the makhan or pepper to give it garnishing effect. So constitution is just a garnishing effect. But what about the underneath inequality? What about the underneath complexity and the narrow-minded views of the people? What about the caste? So Dr. Ambedkar said that what about a certain section of society which is room, which neither has step to go down nor has any steps to go up. It is a static room, and it is in between. Say, if it is, imagine a building of around 30 floors. This room is somewhere near 15th or 17th floor. So neither you can jump off nor you can go up. So such an extraordinary society where we are giving ourselves this wonderful constitution, but it is top. Can you use law as a magic wand? Can you use law as Aladdin Chirag to give special effect and say that okay, overnight all inequalities underneath the societal structure of India will vanish, right? Dr. Ambedkar was knowing well that this is not going to happen, and there he introduced what is known as affirmative action. Affirmative action means the positive obligations of imposition of positive obligations on the state to ensure that level playing field is created for every citizen so that he or she can avail all public goods, including public employment and educational opportunities, equally with others. With this in mind, Article 15.1 was introduced in the Constitution, has been rather introduced in the Constitution. Article 15.2 then has been introduced in the Constitution to ensure that even amongst citizens inter se, be it entry into shops, be it entry into cinema theaters, be it entry into colleges or bathing ghats or public water taps, everywhere, uh, uh, without discriminating with one another on the ground of caste, religion, race, place of birth, sex, etc. The public civil life must be enjoyed. Right. Similarly, Article 16.1 was also introduced by Dr. Ambedkar, very clearly stating that public employment is a very important because as a part of public employment, every citizen is the servant of the entire India. And as a public servant, he must be able to render his services. And Dr. Ambedkar very clearly thought that if the public employment is confined to a particular class, or if particular class is able to perpetuate itself for generations together as the occupier of the most of, then what will happen? There will not be fair representation of the diverse sections of the society in the public employment, and therefore there may be bias. And therefore, in order to uh, 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 address this issue, Article 16.1, he clearly says every citizen must have the equal opportunity to hold public employment. And then 16.2 replicates 51 in prohibiting discrimination on the ground of public employment. One or two additions, for example, place of birth or place of residence. There may be certain exceptions in respect of residence and birth. There may be certain hilly areas, certain there may be areas where there is unlikely that people will easily go and take employment. So for such areas, some reservations may be made. Some facilities may be made so that the people residing there itself may serve the people. So that is employment reservation. And then you have a provision in Article 16 dealing with religious qualifications. Suppose you want to be employed in there, then of course you should have the qualification as a pujari, right? Something like that. Now, uh, uh, these are general provisions, but these provisions also reflect affirmative action. My point is, affirmative action is not confined only to reservation provisions, as is mostly understood. Then, in the first year itself, right, as a constituent assembly, when the parliament sits, in the first year itself, there is a big jolt with Champakam Durai Rajam's judgment. Both Madras High Court and Supreme Court of India clearly holding that caste can be the yardstick to uh, to provide quotas to the people. You know, the famous communal geo was rolled out by the government, and the motive of the government being very good, that every section of the society must get representation, particular medical seats, etc., engineering seats, etc. And inter alia, government is employing Article 46, which imposes obligation on the state to promote the interests of weaker sections of the society. So, despite this clear mandate of directive principles, both Supreme Court and High Court of Madras taking the position, fundamental rights, particularly Article 15 being categorical on non-discrimination on the ground of caste, will prevail over Article 46. And then Champakam Durai Rajam case, in action in the parliament, and the constituent assembly turned parliament, unicameral parliament, taking up the first amendment and inter alia, including in it, inter alia inserting Article 15(4) in the constitution. So Dr. Ambedkar himself being instrumental in insertion of this important article. And what this article says that nothing in this constitution shall prevent the state from making special provisions for the advancement of socially and educationally backward classes of India and SCs and STs, right? So the first action of the parliament in the domain of affirmative action is Article 15(4). Although, in my opinion, because Article 15(1) talks about non-discrimination, and because non-discrimination includes positive obligation to its positive obligation to take affirmative action to create level playing field. Article 15(4) is not did not add anything new. It only made the things obvious. What Justice Subba Rao happened to say long after the 15(4) article. He said it is just a legislative reference, just a reminder to the legislature that, look, equality does not mean equality before law only. Equality also means equal protection of laws. Now, friends, upon Article 15(4), which talks about the advancement of socially and educationally backward classes and Cs and STs, and it is a very general provision. Article 16(4) is very interesting. It uses a slightly different terminology. Nothing in this article shall prevent the state from making special provisions in favor of backward class of citizens if they are not adequately represented in the public employment. So the moral of the story is, if you compare both Articles 15(4) and 16(4), they look replicated. They look layers of each other, but with some differences. For example, the commitment of the Constitution under Article 15(4) is categorical. Special provisions can be made by state. The empowerment of the state to make special provisions is unconditional. the condition which is imposed is the special provisions must lead to advancement. And I think advancement is not a condition. Advancement is an incentive. On the other hand, when you talk about the public employment and the empowerment of the to make special provisions, there is there is some connection between the special provisions and the adequate representation of the backward class citizens. Now, it is interesting that in Article 15.4, the words socially and educationally backward classes and SCs and STs are used. As under Article 16.4, the reference is only to the backward class of citizens. And it is very interesting to draw the comparison and find out whether the conception of backwardness envisaged by both these articles is same or different. And to my mind, one of the courts, either Supreme Court or High Courts, or most of the scholars have paid attention to this important dichotomy. We have simply assumed that backwardness means socially and educationally, social and educational backwardness, right? And I think that has created problems, to which I will turn a little later. But I think it is mistaken to assume that backward class of citizens necessarily mean both social and educational backwardness. Because see, backwardness may be either social backwardness or educational backwardness or combination of social and educational backwardness. Backwardness comes with combination. It is more aggravating. It is more compound rather than when backwardness comes in silos, like when it is social or when it is educational. And I think this point we have missed. Unlike German constitution, you know, the magic with the German constitution is that they have theorized each and every article. They have tried to go beyond the language, and they have tried to find out as many insights and objectives as they could for the materialization of the articles. And their analysis is much more sharp and much more forthcoming, unlike the Indian constitution, where most of the times we have been reactionary. Pardon me, but I would definitely argue that the First Amendment was also a reaction rather than an action. Because why Champakam was decided the way it was decided, nobody went into this question. Champakam Durai Rajam, nobody thought it necessary to find out why Champakam Durai Rajam was allowed to file petition. Nobody bothered to even find out that. If you read Champakam Durai Rajam carefully, Champakam Durai Rajam should not have been allowed to file petition. She did not stand, in my opinion. She was a Brahmin, but she was not qualified. और 1951 में public interest litigation नहीं था इंडिया में, right? So even if you want to say that it was a representative suit, you have to file through CPC. But instead of going into all these questions, instead of going into the technicalities of the articles, one decision was handed down by court and another decision was handed down by the. And I would compare this crossfire of judiciary and parliament in the context of agrarian reform. Though the agrarian reform debate lasted for a long time, the reservation debate, I think, ended with the addition of 15.4. But whether 15.4 brought anything new is a question, and we'll see whether it was enough. Now, for a long time after 15.4, सब कुछ ठीक था, everything was going well, and all of a sudden, then Mrs. Gandhi thought that why not give some reservations to other backward classes. Now, this idea of dividing the people, this idea of creating different sections amongst the citizenry, so poisonous. I tell you, it may sound very good uh, at policy level, but substantively, when you want to divide, you distribute public goods among citizens. If you want to divide people without realizing the consequences, then what happens is the classic textbook case. Mandal Commission is a textbook case of that. Mrs. Gandhi thought that why not create another class, another backward class, other backward class, OBC. So she appointed a commission. Commission went into the exercise of finding who are these other backward class citizens, and काफी उन्होंने research किया. How many schools are there in a village? And again, they wanted to be neutral, being clearly abound in India without caste. Since it is not easy to catalog citizens and list citizens together, they also ended up in landing up themselves in a circle. उन्होंने कहा भाई caste है लेकिन it's not only caste, it's caste plus, and the caste plus is something very dangerous. तो उन्होंने caste plus, whether there are school, caste plus how many people in a community are educated, caste plus how students are matriculated, gone till 10th, how many women, what is the average age of women, etc. So a number of criteria they evolved, and they came out with a survey, and they said that okay, some reservation must be provided. Now the point is the population mass which they examined while coming to this conclusion was the population of British India, right? So what's about objection था कि how can you decide the fate of the population of independent India based on of British India, population of British India? Nani Palkhiwala in his stinging article criticized the government कि आपका universe ही गलत है. But in my opinion, 10% here and there doesn't matter in a country of crores, right? So even if it is assumed that there was a 10% gap between the statistics, you could not have blamed the commission. And it was also not that India had become an extraordinary country, and there was a radical difference in the social status of the millions of the marginalized people in about 30 years after the independence. But somehow Mrs. Gandhi, although she played the card, I don't know what happened. She did not want to push the envelope. Mr. VP Singh, when he became the prime minister, he smelled the blood, and he thought that he would create the history by, by opening this Pandora's box, and maybe by recognizing that silos also possible in conceptualizing backwardness, right? And then he came out with that famous memorandum, official memorandum, providing 27.5% reservation to other backward classes, and to add insult to injury, he also said that okay, let's give reservation to economically backward classes. So I think this is the beginning of new debate and new questions in reservations. The action of Mr. Singh, because VP Singh, as a representative of the so-called marginalized sections of the society, but within him was also a person belonging to majority community. And I believe that somewhere there was feeling in his mind that if these people are getting so, why not my people also should get something? तो ये जो my and die, mine and thine जो मार्क्स बोलते हैं, इसका असर इस पूरी डाइकोटोमी में मुझे दिखता है. And in my opinion, twice or thrice this country was divided after independence, and one of the biggest attempt of dividing the country was the implementation of the Mandal Commission. Now, when matter went to Supreme Court said that from where did you get this idea of economical backward class? There is nothing like economic backward class. A relevant part of the memorandum was turned down, but the rest of the reason, very reluctantly, I say with great responsibility, Supreme Court accepted. Supreme Court said that already you have enough reservation, why you want more? And if you want reservation, then should it go to whom? And therefore, Supreme Court came out with the idea of creamy layer. Backwards among the backward, more backward among the backward. क्योंकि और ये बहुत बड़ा पैराडॉक्स है कि बैकवर्ड क्लास मस्ट आल्सो हैव बैकवर्ड क्लास आल्सो हैज अ क्रीमी लेयर. बट माय क्वेश्चन इज if there is something creamy there, then don't call it backward class, isn't it? Why you want to indulge in this unsolvable problem of having a creamy layer as a tail of backward class and then right? A very difficult exercise which state performed very simplistically by saying कि जिसका इनकम 8 लाख से ऊपर है वो क्रीमी लेयर है, जिसका 8 लाख से कम है वो क्रीमी लेयर नहीं है. तो मेरा अगर इनकम 7,99,999 है तो मैं नॉन क्रीमी लेयर हूँ, और मेरे भाई का 8 लाख है तो वो क्रीमी लेयर है. दिस इज अ रिडिकुलस side effect of such an exercise. But I can read reluctance into the approach of the court. But court's hands were also tied because it is a policy matter how to allocate the public goods, and state decided. Then the controversy whether the OBC judgment is binding, whether it has any impact on SC/STs. क्योंकि OBC judgment में मंडल कमीशन ने ये भी बोला, court said that during the promotions reservations are inapplicable. And court also said that so far as the post of super specialties are concerned, like medical scientists, etc., only merit prevails. Again, मुझे समझ में नहीं आता कि what is merit? What is merit? एक कॉन्वेंट स्कूल में पढ़ा हुआ बच्चा बहुत हाई इंग्लिश बोल रहा है तो वो मेरिटोरियस है, और अगर गांव में पढ़ा हुआ एक बच्चा थोड़ा सा लड़खड़ा कर इंग्लिश बोल रहा है तो मेरिट नहीं है. A person with disability like me, who never could even read the Constitution of India in Braille, if I plead that please give me my Constitution in Braille, then I lack merit. Right? तो ये मेरिट क्या है? मेरिट में भी बहुत सारी क्लासिफिकेशन है. एक क्लास को आप मेरिट मानते हैं, एक मेरिट नहीं मानते. और हमारा कॉन्स्टिट्यूशन भी थोड़ा सा उसमें प्रॉब्लमेटिक है. इफ यू रीड आर्टिकल 335 that efficiency in administration must be balanced with the classes. Now ये बहुत गलत है, बहुत बड़ी स्टीरियोटाइपिंग है. As if backward classes are allowed entry in public employment, they create problem for efficient administration. As if efficient administration become deficient with the entry of backward classes. लेकिन हम रिएक्शनरी हैं. फिर एक अमेंडमेंट डाल दिया हमने. अमेंडमेंट डाल के एक प्रोवाइजो आर्टिकल 335 को, which was again in my opinion insult to injury. कि nothing in this article should prevent the state from lowering the standards evaluation and even marks for passing the tests vis-a-vis SCs and STs. तो आपने क्या किया कि ठीक है आप बेचारे हैं, उनके मार्क्स कम आने दो, उनको लो स्टैंडर्ड, उनके लिए स्टैंडर्ड लो करो, सो दैट जैसे तैसे वो अंदर आ जाए. So instead of going for their empowerment or instead of questioning your own assessment methods, अब आप एक एग्जांपल लीजिए कि आप कॉमन एंट्रेंस टेस्ट जब प्रिस्क्राइब करते हो लॉ के लिए, आपने 80% क्वेश्चंस उसमें मैथमेटिक्स के डाल दिए और 20% क्वेश्चन सपोज आपने उसमें इंग्लिश के डाल दिए। अब ऐसी एग्जाम कौन पास होगा? वही जो जिसको इंग्लिश आता है और मैथ्स आता है, बाकी भी तुलना हो वो पास नहीं हो सकते। एंड such people may also belong to the category. Therefore, this merit is problematic, right? What is merit? आपने decide कर दिया ABC is merit and therefore it becomes merit. So friends, with this particular amendment, I think we have perpetuated the hierarchy and we have perpetuated the superiority complex कि भाई तो मार्क्स कम किए बिना ये लोग आ ही नहीं सकते, right? Now friends, this has therefore given rise to a very interesting question, whether merit is ableism. क्या आप ये सोचते हैं कि when only a particular section of society with its capacity to a particular percentage of mark, unless matched by the rest of the society, we are not merit and you are merit. आप मेरिट क्यों? क्योंकि आपको हैबिट है, आप सालों से वही एग्जाम दे रहे हो। हमने तो अभी देना चालू किया है। सपोज आप 10 साल से कार चला रहे हो, हमने आज कार चलाना चालू किया, तो इज देयर नॉट अ डिफरेंस बिटवीन यू एंड मी? वेयर इज द लेवल प्लेइंग फील्ड? व्हाट अबाउट द लिंगरिंग डिस्क्रिमिनेशन? इंटरेस्टिंग आर्गुमेंट जो डिबेट और नया क्वेश्चन जो आता है वो ये आता है कि ओके, lingering discrimination is there, systemic discrimination is there, but why we should be bothered about the जो डिस्क्रिमिनेशन आपके साथ पास्ट में हुआ, आपकी पिछली जनरेशन में हुआ, उसके लिए हम कॉम्पनसेट करें आपको? why we should compensate? तो जो इंटरजेनरेशनल इक्विटी की बात आती है, but in my opinion society does not survive or sustain in bits and pieces, right? It is a system, it is a vehicle, it is a seamless web. Therefore, you cannot say that the impact of the past does not felt by the present and future. And therefore, in my opinion, so long as the past is present, so long as the past is visible in present, the responsibility of generation is equal. And I can give you just one example. Do a survey and find out how many IAS officers in India belong to class community. How many IAS officers in this country are disabled? How many IAS officers in this country are women? How many IAS officers in this country belong to LGBTQ community? I will lose a bet of 1,000 rupees if you can show me the figure, which would be more than 20%. So therefore, when this argument is presented, merit, efficiency, so on and so forth, question arises, किसकी वजह से efficiency नहीं है एडमिनिस्ट्रेशन में? 80% तो अभी भी आप लोग ही है, फिर किसकी वजह से नहीं है? How dare you to say that efficiency is limited? अभी तो आप ही लोग हो, 80% तो आप ही हो, आप ही चला रहे हो. So therefore, this talk of efficiency is completely nonsense. Then comes a very interesting question, was propelled by Prime Minister with the introduction of 100th Amendment. उन्होंने कहा कि amongst forward also there may be economic backwardness. अब ये बात हजम नहीं होती, difficult to digest how forward section of the society can backward. But मराठी देख ले लीजिए आप, वो बोलते हैं कि भाई we are politically forward but economically backward. So especially क्या social SEBS, specially economic special economic social and educational backward class, SEBC. एक नई टर्मिनोलॉजी उन्होंने इंट्रोड्यूस कि पॉलिटिकली हमारी कैबिनेट हमारी है, जाट हरियाणा में हमारी क्या पूरी कैबिनेट है ऑलमोस्ट, बट वी वांट रिजर्वेशन. फिर एक नया क्वेश्चन और निर्माण हुआ कि आप रिजर्वेशन लो मेरे भाई, बट डोंट टच माय रिजर्वेशन. So OBCs are saying, look, as Marathas, you may have your share of the cake, but that does not mean that you will eat my share of the cake. अरे भाई पर लेकिन केक तो एक ही है ना, और केक का साइज थोड़ी है, केक खाने वालों का साइज बढ़ रहा है. And my problem is that we are treating reservation like a cake. Reservation is not a cake. Reservation is not a permanent solution. Reservation is merely a temporary solution to create level playing field, to ensure that there must be both equality of opportunities as well as equality of result. तो अनेक इंटरव्यू कोर्ट ने किए, बालाजी केस में कोर्ट ने कहा 50% से ज्यादा नहीं होना चाहिए. इंदिरा सामने में कोर्ट ने कहा कि क्रीमी लेयर होना चाहिए. फिर उन्होंने ओबीसी को प्रमोशन नहीं मिलना चाहिए. बाद में फिर अमेंडमेंट्स आए. Then amendment said that promotions may SC/ST can be given reservations. Then catch-up rule आपने छोड़ दिया और sequential seniority rule आपने लिया. Catch-up rule means even if you are promoted earlier than me as a SC/ST, when I join you, when I catch you, because I was senior to you, even if my promotion is later, I will be senior to you. But that equitable catch-up rule was also one up. And consequential seniority, so direct seniority. If I'm promoted earlier than you, I will be senior to you, despite the fact that you are senior to me when I join employment. ये सब कुछ किया, फिर भी प्रॉब्लम जस का तस. तो मुझे लगता है, और एक 2 मिनट में इनके बारे में बोलूंगा, then I will conclude in about 10 minutes. 15.3. Another interesting example of affirmative action. Nothing in this article shall prevent the state from making special provisions for women and children. How double-edged weapon this provision can be. इसी provision use करके आपने adultery जैसी dreadful provision को sustain किया for a long period. Be it Revati's case, or be it that other famous case I've forgotten, wherein the adultery's constitutional validity was challenged, right? इसी प्रोविजन को करके आपने बोला कि जेलर विमेन नहीं बन सकती. इसी प्रोविजन को यूज करके आपने बोला, वैसे अडा मैडम इज एक्सेप्शन, बट आई विल से दैट इसी प्रोविजन को यूज करके सुप्रीम कोर्ट ने बोला कि ऑल women colleges, exclusive women colleges must only have women principal, right? Luckily, with Joseph Stein, adultery is given up as a criminal provision, and with Shamripa, women are allowed to enter into the temple of their choice. Recently, with Nitisha, Colonel Nitisha, 2021 judgment, Justice DYC has recognized the right of women to have permanent commission with men. और उन्होंने कहा सिर्फ आप लोएस्ट क्वालिफिकेशन के विमेन को परमानेंट कमीशन नहीं दे सकते. यू हैव टू पुट द सिस्टमिक बैरियर्स व्हिच स्टॉप्स विमेन फ्रॉम गोइंग फॉर परमानेंट कमीशन. तो भारत के इतिहास में पहली बार इनडायरेक्ट डिस्क्रिमिनेशन विदाउट डिस्क्रिमिनेटर, राइट, जो हम मानते ही नहीं है. Why Dr. Jain is only principal as a blind person in India in law colleges? Because of systemic discrimination. System is discriminatory. System believes that a blind person is good for nothing, probably, except maybe singing few songs and entertaining the crowd, right? So that systemic barrier, that systemic mind, that systemic block in mindsets, ये block आपको ऐसे किसी इंसान में नहीं दिखेगा. When Supreme Court, for example, said that blind person is ineligible to become judge in a lower court because he cannot read, he cannot write, I think the judge was joking. But still, it was a decision given by Supreme Court, and it lasted till it was blasted by Justice DYC when he said that it is no longer a good law and has to be overruled. So when the discrimination lies in the system itself, Sachat Gharat, systemic discrimination. So Justice Chandrachud resolved the crisis when he said that we do not want only discriminators to be booked, but but we also want to nip into but discrimination in the system. So you have to change the system. You have to revamp the system, emancipate the system. You have to break the bottlenecks, right? So that is another very interesting turn to the reservation debate. And Chandrachud, when he went for permanent commission for women, he did not say that it is a reason, that it is their passion. And it is and it should be our obsession to ensure that all our better halves, all our fair sexes, they should be the part of the army, right? Interestingly, in a very telling judgment given by CAT recently, they were trying to afford 80% reservation for nurses in All India Medical Institute case. And yeah, yeah, yeah. You can leave. Those who want to leave from my class, you can leave. I'm sorry, ma'am. Now, I will quickly like that judgment. The All India Medical Institute case, the question before the court was, can you have 80% reservation? So the CAT held that reservation under 15.3 is different from reservation under 16.4. When we give reservations under 16.4, we are talking about a citizenry, and we are talking about the backward class of citizens. So a particular sect of the citizens is the focus. Whereas when we are giving reservation under Article 3, our focus is on entire woman population. So the context of 15.3 and 16.4 is different. This is a breakthrough, and this has ignited a new debate. In fact, read in between the lines, CAT is trying to argue that it is not reservation, it is participation, it is emancipation. Why? Because from entering into the employment market. But my only complaint is why only for the post of nurses? Are you trying to create a glass ceiling that the jobs of nurses may be performed better by women, therefore give them 80% seats? And my last point, can men face sex discrimination during reservation? I feel that with the lapse of time, the idea of division of labor also has undergone change. And if division of labor is influenced by sex, suppose you are identifying jobs of nurses for women, jobs of jailer for men, you are saying that in all women colleges, only ladies must be appointed as lecturers and principals. That probably, this is again a new debate, because you are trying to perpetuate both. You are trying to perpetuate compartmentalization. You are trying to say that, okay, a particular class must be looked at as it is. Besides, my last point, can we look at backwardness? And this is a very big question. I don't have any answer, but I want to raise this question, try and answer. Can you really look at backwardness in silos? For example, can you say that economic backwardness can sustain and can deserve you reservation, even if you are politically and socially, you are elevated, politically, socially, educationally, you have all qualities. Maybe your income is low. Maybe you have some economic issues, but as a member of society, your social status is not low. Can, for example, a member belonging to SC/ST and a member belonging to WS, can they be equal so that they deserve equal affirmative action? That is my question. In my opinion, it is perennially wrong. Compare economic backwardness with social and educational backwardness. At times, economically and well off, but yet your social educational backwardness will hamper your position, hamper your growth. Will always remind you that okay, look, howsoever rich you are, look at social status here. What is your social status? Similarly, and this is another new. If I belong to LGBTQ, if I am disabled, if I am belong to a profession which is uh, which is unlikely to be taken by any other community, scavenging. Mind you, let us imagine that somebody from heaven gives me modern technology to practice my profession. Somebody from heaven uh, gives me all the facilities as a disabled. Somebody from heaven gives all the facilities to LGBTQ. Still, the so-called ableist world will never look at us equally, right? So I will conclude uh, a reminding and all of you the memorable words of my my friend and great philosopher Sandra Friedman when she said that you cannot capture equality in either or framework. You have to identify the multi dimensions of inequality. Inequality is in terms of lack of participation, inequality in terms of lack of proper distribution, inequality in terms of lack of proper recognition, inequality in terms of proper inclusion. And if I were to add to this the words of my favorite judge, Justice DYC, and he said two things. We quoted Gandhi. If you want to be the part of the change, be the perfect one. And number two, he said, if you want to fight disability, if you want to fight backwardness, the fight must begin from internal mindset, because the problem is in our mind. Problem is not elsewhere, right? So I thank Modern College for giving me this wonderful opportunity to unwind on a very complex topic of reservation and a few questions. And I hope that this was of some use to students. Thank you very much.
Thanks a lot, sir. Yes, definitely. It was very informative. And I would like to ask if there are any questions for sir. We would like to have a couple of questions quickly. Would anyone like to pose any questions?
Sir, I may have one question for sir. It was a very mesmerizing lecture. Can I have a question, please?
Yeah, please go ahead.
So very good afternoon, respected sir, and respected dignitaries for the organizing committee and my dear teachers. Myself, Amit Giri. I'm a student of third year LLB course at Modern Law College and would like to have a question from my side for sir. Sir, am I audible to you, sir?
Yes. Please continue.
Yeah. Sir, you started your lecture with the, quoting Karl Marx and how the journey of, the political reforms to social reforms, then the division of labor and the economic benefits out of division of labor and, the unequal distribution among the society and the classes of modern India has been the journey. Thank you, sir. That was a very delightful journey. My only question to you is, how do you address the problem of fair competition uh, amongst the classes? But there should be a fair competition amongst the classes residing in India with the constitutional means. But then there is unfair means as well, like the economic issues of backwardness, the social issues of backwardness, the inequality issues, and things like that. So just if you could just, from point of view of research, if you could just make me understand the fair competition view in this modern India.
If you know the competition law, right? Although it is different slightly, but the linchpin underlying competition law is that the dominating class must not be able to have its way. It should not be that my way is the highway, right? So fair competition is possible only when all the classes are equal, right? Now the problem with anti-reservationists is that they say that because of reservation, the competition is affected. But my argument is there equal, are the forward and the backward equal? They are not equal. So fair competition is only possible when the two sides are equal. Even amongst the forward, now forward people, the so-called open category or whatever, they say that they are also amongst them backward, as Modi ji has said, no economic backward. So there is no, when we lack equal, there is a question of fair competition, right? So once you start down the road of guiding the people by using different labels of backwardness, as I call it, this labelization is very dangerous. तो आप डिवाइड करने से अच्छा है, you try to create equal level playing field. You have to accept that we have failed in our reservation policy because we have not been able to implement it properly. Now we should try else other things. Can we give scholarships? Can we ensure that all sections are able to be in all streams? How many backward class students really can afford medical education in private colleges? आप गवर्नमेंट का छोड़ दीजिए, एडेड कॉलेजेस का छोड़ दीजिए, जो बहुत कम है, लेकिन बल्क कहाँ से आ रहा है, मेजोरिटी कहाँ से आ रहा है, वो तो प्राइवेट से आ रहा है ना. तो वहां पे आप क्यों नहीं जा सकते? Because barriers, what Martha Nussbaum says, कि rights without capabilities is degree without, क्या बोलते हैं, decree with execution, right? तो degree है आपके पास, लेकिन you can't execute it. So rights and capabilities have to go together. Right? That's what I feel. Fair competition will happen as soon as you make people capable. Don't just empower them with rights, but make them capable.
Thank you, sir. Thank you so much. Thank you. I'm highly obliged that you have answered my question. Thank you so much, sir.
Thanks a lot, sir, for addressing the question as well. And yes, sir, it was a very informative session, and definitely, I think so. It has cleared the unsolved parts or unsolved mysteries around reservation, and definitely, it was a very informative session. Thanks a lot, sir, for being a part of this lecture series. And I thank you from the entire college, Modern Law College, for being a part of this lecture series. Thanks a lot, sir. And now, yes, and now I would like to invite our next faculty for the next lecture. The next faculty who is going to deliver the lecture is Professor Dr. Paramjit Jaswal, sir. I would like to give a brief introduction of sir, and also I would like to welcome him once again virtually to Modern Law College. Sir has been visiting the college for many years now, and now I would like to welcome him virtually. Before that, I would like to give a brief introduction of sir. Professor Dr. Paramjit Jaswal, sir, is currently the Vice Chancellor of SRM University. With the educational qualifications of sir have been, sir has done his BSc, BL, LLB, LLM, PhD, and also sir has been a Fulbright scholar. Sir has a vast teaching experience of 37 years, along with research experience which is as wide as 39 years. The fields of specialization of sir are constitutional law, administrative law, human rights, and environmental law. Sir has published a number of books in total, which are 43, since a period of time, over a period of time. Sir has also published a lot of research papers in reputed national and international journals. In total, Sir has published 63 research papers. Sir is also a research guide and supervision experience for various PhD students. Sir has received a number of fellowships and scholarships over a period of time. I said, he was awarded the Fulbright Scholarship by the United States India Educational Foundation, New Delhi in 2017. He has been awarded Amity Academic Excellence Award in 2019 by the Amity University. Also, Sir has been awarded the Young Talented Teacher Award by the UGC in the year 1994, and also he has been awarded the Bharat Jyoti Award in 2006. Currently, Sir is working as the Vice Chancellor of SRM University, but before that, Sir has worked in various capacities in various different institutes and universities. Before this, Sir was the Vice Chancellor of Rajiv Gandhi National University of Law, Punjab at Patiala since 2011. He was the former VC of National Law University, Raipur. He was the former director of University Institute of Legal Studies, which is located in Chandigarh. And there's a long list of the administrative experience that Sir has gained over the years. And we are really lucky to have you once again, Sir, on this occasion of Azaadika Amrutmahotsav. And I would like Sir to take over from now and deliver his lecture. Over to you, sir.
Thank you very much. Am I audible?
Yes, sir. Yes, sir. You are audible.
Okay. Thank you very much. I'm grateful to Dr. Sunita Adhab, the principal of Modern Law College, Dr. Ananya, and all other faculty member management for remembering me and asking me to deliver this lecture in the series. I have missed the previous lecture. I wish I could have attended for Dr. Sanjay Jain, but he was speaking so well on a very important issue, constitutional issue of reservation. I could just hear him for about 5 minutes, and he addressed various issues which are currently are moot points as far as India is concerned. The topic on which I'm going to speak about is the constitutional promises and performance over the last 70 years after the commencement of the Constitution. Constitution for any nation is a basic document which lays down the structure of the governance in the country. Not only that, it also defines the powers and the limitation which are imposed on the different organs of the state. And we are very lucky that the framers of our Constitution, the founding father, they debated and discussed various provisions before finalizing the draft for about 3 years, and ultimately came out with one of the lengthiest constitution what we have at that time, with 395 articles and with 7 schedules appended to it. The founding father had a number of things before them. They had the experience of exploitation by the Britishers for 300 years in the past. They had seen the Second World War, the scourge of Second World War, and the consequences of it. That was the time when Universal Declaration of Human Rights was also being drafted after the Human Rights Commission was established in 1946 by the United Nations. The birth of United Nations and the promise to the people, that was before their eyes. And all those positive features they tried to incorporate into Constitution of India. To the present generation, who are born in particularly 21st century, it is very important to know that what are those promises which the constitution makers made to its people, particularly to its citizens. To a citizen, a constitution of a country is like a holy book. When we believe in a particular religion and we worship a particular book, I think every citizen has to worship the constitution of that nation. Our constitution is very explicit, very wide in its scope. And if we want to see the promises which the maker of the constitution had made in the constitution, then we have to look to the preamble to the Constitution of India. We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure all its citizens. Four things. These four things are the four pillars on which the entire constitution stands. The rest of the provision of the constitution, they are explanatory of these four pillars of the constitution. And they are justice, social, economic, and political, liberty, liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and finally, the fraternity, assuring the dignity of the individual and unity and integrity of the nation. And in this background, this constitution was adopted by us. It was not thrusted upon us. Now, over the 70 years, how far we have traveled in the background of these promises, four pillars of promises: justice, liberty, equality, and fraternity, and also the conceptual part of the governance which we have, the sovereign, socialist, secular, democratic republic. How far we have traveled, how far we have been able to achieve those promises which were made when the draft was adopted in November 1949 and ultimately came into force, this constitution, on 26th of January 1950. It is very difficult to give you the entire picture in 1 hour lecture, but I'll try to summarize few points, and if I leave certain important points, I may be pardoned for that. Let me start from the operative part of the preamble. We the people of India, having solemnly resolved. That means this constitution was not thrusted upon us. It is our constitution which we have given to ourselves. Now, what we promised, what kind of a governance we promised, then we have to read the preamble further. We, the people of India, having solemnly resolved to constitute India into sovereign. The first word is the sovereignty. Now, what is this sovereignty means? Sovereignty means that we are supreme. We are not any more subordinate to anybody. We have large number of examples where we have demonstrated that yes, we are sovereign. When armed forces were to be sent to Iraq or Iran, and the USA asked us, we did not join hands. USA may be power number one of the world, but we are not under the dictates when it comes to its own exercise of power of sovereignty. So some people say we are the member of the Commonwealth countries and the Queen is the head of the Commonwealth community. Well, we are member there with our own volition, with our own freedom. The day we find any policies of the Commonwealth community against the Constitution of India, we can come out of it. We are not subordinate to the dictate of even the Queen of England now. So that is the sovereignty. We are supreme within our own sphere, within our own constitution. Socialist, as you know that the word socialist was also not there in the beginning of the constitution when the constitution was adopted. But we have been a socialist from the very beginning. If I go back again, as far as the performance is concerned, when we talk about we the people, today we are not together in the nation. in the performance, if we say the, the growth of the regional parties, the growth of the local politics, the growth of certain segments of the people with the different faiths, they have divided the nation into I and they. So it is no more we. We hardly talk about together in the constitutional sense. Whenever any constitutional issue is before our eyes, we talk about I have this and this, they have the duty this, and when we talk about rights and duty, I have the right and they have the duty. Similarly, when we talk about sovereignty, you have seen in the recent past some segment of the society raising slogan, uh, we want Azadi, Bharat Tere Tukde Tukde. Now, when you divide and we are talking about the division of the nation into parts, the different parts, are we talking about unity? Are we talking about sovereignty? We have achieved our freedom. What kind of Azadi we are asking for? And at what cost? When we talk about the socialism, which I was talking about, if you see part 4 of the Constitution, that was originally there in the Constitution of India, that part 4 of the Constitution contained the directive principles of state policy. Just to make the picture very clear, when originally we talked about the framing of the Constitution, not post-independence, but pre-independence also, when the Congress had a demand that we must have the freedom and our own constitution, when we had the 19th Karachi Resolution in 1931, at that time there was no division between fundamental rights and the directive principles. But the framers of our constitution were very wise, and they divided the rights into two components. One set of rights to what we call fundamental rights in part 3 of the Constitution, and they were of the opinion that these rights, what we name them as civil and political rights, they are to be secured to the citizens as early as possible. And their assurance to the citizens or the people of this country cannot be postponed for any future. And that is that is why they were made separate from the rest of the social, economic, and cultural rights, and they were made enforceable rights, and right to enforce was itself made as a fundamental right under Article 32 of the Constitution in Part 3 of the Constitution. This is the beauty of our Constitution, that fundamental rights are not only fundamental, not only enforceable, but right to enforce these rights is also a fundamental right, as I explained in Article 32 of the Constitution. On the other hand, the framers of the Constitution were aware of the fact that there are other equally important rights, but they cannot be provided to the people immediately at the time of the commencement of the Constitution. But keeping in view their importance, they must be taken into consideration by the different governments from time to time whenever they make the policies. That is why they were separated from Part 3 and incorporated in Part 4 of the Constitution as directive principles of state policy. That is, they are a kind of directions to the government, all the three organs of the government. That is why if you read the definition of the state under Article 36 of the Constitution, it says the meaning of the term state shall be the same as defined under Article 12 of the Constitution in Part 3 of the Constitution. And when we talk about the nature of these directive principles, then you see that these directive principles in Article 37, it is clearly mentioned that principles contained in this part are not enforceable. Nevertheless, they are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in the making of laws. Now, my question is that these social, economic, or cultural rights, to which we call the rights of the society as a whole, as compared to the individual fundamental rights of Part 3, then can we say that the rights of the society, which are fundamental in the governance of the country, are they less important than the individual fundamental rights? To my mind, the answer is obviously no. They are not only equal important, but they are in sometimes they are more important. And during the course of my lecture, I will also try to demonstrate how they are more important many a times as compared to the fundamental rights. And further, the last part we must also take into consideration that it is the duty of the state. We must undermark that it is the duty of the state to apply these principles in the making of laws. So whenever the state, any government, whether it is of political party A or political party B, it doesn't matter. The ruling party, whenever they make the law, they have to take into consideration these principles, and they are to be assured. Some of you may be thinking at this stage, if they were really so important, then why they were not made enforceable? I give you the reason for that. That, for example, the unamended Article 45 of the Constitution, which was the only provision in the Constitution which laid down the time limit for achieving certain target laid or provided by the Constitution. It provided at the original unamended article that the free and compulsory education shall be provided to all the children below the age of 14 years within 10 years from the commencement of the Constitution. Our Constitution commenced in 1950, and the objective of Article 45 was to be achieved by 1960. But if we see in reality today, can we say that today all children below the age of 14 years, they have got free and compulsory education? This objective has not been fulfilled even today after so many years. If I take this very example further, then it was realizing the importance of this particularly article that yes, unless we have primary education or the basic education, which is available to all the children, we cannot understand our rights, we cannot understand our duties, and therefore part third, the entire part third, which talks about the individual rights, that becomes meaningless. It was in 92 and 93 when the Supreme Court of India, through Moni Jain and Unni Krishnan case, decided that right to free and compulsory education as provided in Article 45 of the Constitution is though a directive principle, but it should be treated as a fundamental right. In other words, the Supreme Court declared it as a fundamental right. And we have a provision, Article 141 of the Constitution, which says whatever the Supreme Court says, that is binding on all the authorities within the territory of India. My question is, what is binding on authorities of within the territory of India? Only thing which has the force of law. Therefore, this judgment laid down the law that right to free and compulsory education is equal to fundamental right. It took about 10 years more for the Parliament of India, which amended the Constitution of India in 86th Amendment and in 2002 added Article 21A of the Constitution, in which it was provided the children between the age of 6 to 14 years are to be provided free and compulsory education as per the law to be made by the state. Again, it was not a clear-cut fundamental right. The law was to be made, and it took 7 years more for the Parliament to enact a law for providing free and compulsory education, and which was enacted in 2009. And it took still 1 year more to implement that law from 1st of April 2010. But despite having a specific law on the point, and despite the fact that there is a provision, Article 21A of the Constitution, specifically providing as a fundamental right for free and compulsory education, if we see the performance-wise, because that is what my topic is, that promise was to achieve the objective within 10 years of the commencement of the Constitution. And even after 70 years, if we see, can we say today that all children below the age of 14 years have actually access to education. When we talk about access to education, it is not only the availability of a provision of going or having a provision to go to school. Do we get that quality education? Today, if you study the data of different schools in the different states, in many places, there are no government schools. The private schools are beyond the affording limit of an ordinary person. Their fee structure is so high. And where the government schools are there, they also many a times do not have the proper infrastructure. And the most hurting thing is many schools are not having the teachers to teach the students how they will get the quality education. We have a new education policy of 2020 in place. The government is taking many steps. But the fact also remains in the performance side that in the state of Punjab itself, or Bihar, or Maharashtra for that matter, or take any state, thousands of vacancies of the primary teacher, they are lying as such, they are not being fulfilled because of different political considerations. Now, unless we have teachers and unless we have quality teachers, how can we think about imparting the quality education at the basic foundational level? If your foundation is weak, your structure is going to be unstable. And that is what is happening in India. Today, we talk about that our universities do not find place in the world ranking. It is very, very difficult to find a place because we have to compete in the world. And our higher education system is also not that strong nationwide because of the weak foundational structure of the primary education. So on the performance wise, we see that we have not been able to achieve this objective of providing free and compulsory education. Why it was not made a fundamental right to begin with at the commencement of the constitution? Because that time we wanted a number of schools, we wanted a number of teachers, we wanted the infrastructure, and the economy was at a nascent stage because our economy had already been shattered. It had been exploited by the rulers prior to our independence. We talk about the other objectives which are given in the directive principle. I'm happy that I was not aware, but I'm happy that the previous speaker addressed a wonderful question with regard to the reservation. I will not go in deep into that because this point has been discussed, but there is a very important distinction which we must understand if we want to see the difference between promise and performance. The promise was to provide equality to all. But the previous honorable speaker very rightly distinguished, are we already equal? So we had to bring those who are unequal to the same platform to bring the equality so that we can move forward on equal footing. And for that, we have to understand the meaning between or the difference between the distributive justice and affirmative action. For bringing the have-nots to the upper level or to bring all people of the country to the equal platform so that we can equally enjoy the fruits or the benefits promised by the framer of the Constitution, we have to take certain affirmative action. And the reservation was thought to be one of the provisions, but whether it has succeeded or not, I think you have already been told on this issue. Reservation, particularly when we talk about it, is in the different sense. Reservation in education institution, reservation in employments, political reservation. And as you are aware, by Amendment Act of this 2020, 104th Amendment Act of 2020, Article 334 has been amended, and the political reservation has been extended further for 10 years, that is up to 2030. Now, this provision also was kept only for 10 years. I'm talking about why I don't want to go deep into the issue of reservation, but when I'm talking about the performance of the Constitution, when the Constitution came into force, 334 originally provided that there will be certain constituencies for elections into the parliament as well as to the state legislature, which will be reserved for the scheduled caste or the scheduled tribe. The reason was that it was thought that the people from these constituencies, they will get elected. And since they are coming from the reserved constituency, they themselves belong to that lower caste, they will be able to pinpoint the inequality to their class in the parliament or the legislature of the state, so that the law could be made in the parliament or at the state level to bring up them within the period of 10 years. The reservation, for this political reservation, was also mandated to be provided only for the period of 10 years from the commencement of the Constitution. But for political consideration, after every 10 years, by constitutional amendment, this period or the time period has been extended by every 10 years and right up to now 2030. And we do not know how long this political reservation will continue. I think the point must have been made clear to you by the previous honorable speaker, but I still make it clear as far as the provision, what I call them enabling provision in the part 3 of the Constitution are concerned with regard to providing reservation to the socially and educationally backward classes in case of admission, and to the weaker section and the backward classes with regard to the employment. There was no time limit provided, and there is till date no time limit. This reservation, depending upon the policies of the state, can continue for years to come, or that may stop together. It is totally dependent on the policies of the state. Now, if we see other directive principles which are focusing on the socialistic principles or the social justice, the operative part after Article 37, if you read Article 38 of the Constitution, it talks about providing social justice and social welfare to the people in all spheres of life. Particularly, Article 39 was focused on to provide equality by bringing agrarian reforms. And when the Constitution came into force in 1951 itself, and the Nehru government tried to bring the agrarian reforms, it conflicted with the right to property, which was considered as a fundamental right under Article 19(1)(f) and read with Article 31 in Part 3 of the Constitution. So the judiciary and the parliament, they started fighting with each other on the issue of social justice or social agrarian reform. And it was then that we had to amend the Constitution of India, and ultimately Schedule 9 was carved out, and it was provided that if any law is placed in in 9th schedule, then that shall not be called in question in any court on the ground of equality, freedom, etc. And that shall be considered as immune from the judicial review. Now, if you see Article 39 small b and small c, ownership and control of the material resources should be so distributed so as to subserve the common good. And there should be no concentration of wealth in the hands of few individuals. That was nothing but focused on agrarian reform. Now, agrarian reform itself is a complete topic. But even today, after 70 years of the commencement of the Constitution, we find that we have failed to bring the agrarian reform. There is a concentration of wealth in the hands of few individuals. The rich have become further rich. The poor have become further poor. Ownership and control of the material resources is also not equally distributed. It is also concentrated. So despite the constitutional promises, the objective of 39B and 39C, that has remained unfulfilled. The other provisions of Article 39 of the Constitution, for example, securing means of livelihood to everyone. Today, we find that many people are struggling to have roti, kapda, and makan every day. The means of livelihood is not secured to every person. We have seen, particularly in the pandemic situation, COVID pandemic situation of last year and even now, how the poor workers, they are leaving their place of work. Some people last year died while going home, leaving their place of work. We could not protect and ensure that everybody has a means of livelihood. Another area where we have failed to bring equality is the equal pay for equal work. Article 39D, small d of the Constitution provided that there should be equality in pay as far as the work is concerned between men and women. But we have examples in the country how differentially the people have been treated in India, even many a times by the government. And in fact, the government has been from time to time bringing such a notification or executive order which are in contravention with the Article 39D of the Constitution. I'm aware about a notification which was brought about in the state of Punjab or in state of Rajasthan or Maharashtra. And there are many other states that if a person is employed in a regular job in the state, for 3 years, he will be paid only the basic pay of the scale without any allowances, including the dearness allowance or the house rent allowance, etc. And it is only after the 3 years he or she will be paid the salary along with the allowances. Is it not violation of right to equality? These are the many issues which remain to be fulfilled. The human conditions at workplace, they are still worse at many places, including the industries which are under the ownership and control of the government. Children are required to be protected from exploitation as per Article 39, but there are day in and day out the stories, particularly we listen to 100 non-stop news on any channel, whether in the morning hours or in the evening hours, you'll find at least the 50% of the news are focused on the exploitation of the children or the women. Why we have the FOXO Act and everything, but despite legislation, have we been able to protect our innocent children from exploitation? They are still below the age of 14 years. They are still working in dhabas and industries in which their employment is totally prohibited. Another provision which is there is the equal justice and free legal aid, Article 39A of the Constitution. Though it is a directive principle, but access to justice has been interpreted in the similar sense as equal pay for equal work by the Supreme Court as a part of Article 21, read with Article 14 of the Constitution, dealing with the right to equality and right to life and personal liberty. When we talk about access to justice, nothing rankles more in the human mind than the sense of injustice. Today, we are lucky to be in this country that during pandemic period, at least among many other frontline workers, there are 3 areas which are worth mentioning. One is the health people, the doctors, hospital people, paramedical staff. They have been working day in and day out to treat the patients despite their limitation which we have because of the large population in this country. Second is the educational sector. In most of the cases, the teacher, they immediately switched over from offline mode to the online mode, and they have been imparting education to save the academic year. Even so much so, even examinations were taken by the education institution on the online mode. And the third one is the courts. Our courts never stopped in totality. despite the heavy rush in the courts, they had to go online. But online also they have been attending, and now there was a news that some courts are going to be operative, that 24/7 and online justice can be provided. But the question remains, is it possible for every individual in this country to have easy access to justice? Only those can afford the justice who are having the heavy pocket to pay the lawyers, the heavy pay which they have to pay to the lawyer for fighting their case keeps many individual away from the doors of the courts. This, the Supreme Court of India or the higher judiciary of India has yet to become the judiciary of Indians, because unless and until each and every individual gets the access to justice freely. We have lok adalats, we have free legal aid in the law school, but most of them, they exist on paper. In the living reality, in the villages, the access to justice is a distant dream. Though the Supreme Court of India has given the clarion call, and it has interpreted the equal access to equal justice of free legal aid as part of the procedure established by law under Article 21 of the Constitution. When I talked about right to work and right to livelihood, the living wage is another directive principle which has to be taken into consideration. Similarly, participation of the workers in the management under Article 43A of the Constitution, that has also to be ensured. It remains a distant reality. One of the another very important principle which is enshrined in the Constitution, and on which the judiciary has reminded the executive and the legislature, but still it remains to be unfulfilled, is uniform civil code. Right from 1956 onwards, through Shah Bano case and many Sarla Mudgal case, there are many judgments of the court where the Supreme Court has reminded the parliament that we are a secular nation. We need to have a uniform civil code. Today, our civil matters, particularly the marriage, the property, etc., they are being governed by our own personal laws. No doubt, the Constitution of India recognizes the importance of customs. But if you read Article 44 of the Constitution, the state shall make endeavor to bring uniform civil code. Uniform civil code, as it is misunderstood by many of us, does not mean the implementation of the Hindu code for all. That is not the uniform civil code. Uniform civil code is the personal matters, including marriage, inheritance, succession, etc., when they are governed by the common law and the common courts, applying to all the people living in this country, irrespective of their religion. What we can decide is we can take some good parts of a Hindu law, or a Muslim law, or a Parsi law, or a Christian law, whichever is the best part, we can take that part and enact a common civil code. If we can have a common civil code in Goa, why can't we have in other states of the country? That is another a very important issue. Article 46 again talks about taking into consideration the educational and economic interest of weaker sections. Weaker section includes the scheduled caste and scheduled tribes also. But unfortunately, if you study the annals of history of implementation of the constitutional promises in the last about 70 years, on the issue of Article 46 of the Constitution, right from the very first case on this Champakandra Rajan 1951 onwards to the latest controversy, we find that we have been not fair to the weaker section in implementing this particular provision of the Constitution. We have to protect the economic and educational interest. That need not be only by the method. Reservation is one method. What we have to take is the affirmative action. We have to ensure distributive justice. And for this affirmative action and the distributive justice, the implementation of Article 46, read with Article 15, 16, and 335 in particular, that is to be ensured. But we have not been able to travel a long distance in ensuring the implementation of this provision. Article 47 talks about improvement of the standard of living and public health. Yes, we have achieved some success in this, but again, a quality health to all, to every citizen of this country, is a distant dream. There are many people, because of the death of the hospital or because of the hefty cost, particularly by the private hospitals, the right to health, that is a distant dream in this country, and we have not been able to achieve this objective also. Another provision was added in 1976 into the Directive Principle, Article 48A, with regard to the protection of environment. We are lucky to be in this country where protection of environment is a concern in the Constitution itself. Though it was originally incorporated in Directive Principle, but thanks to our judiciary, through the judicial interpretation, the right to live in a healthy environment has been treated as a part of Article 21 of the Constitution, and hence it is considered as a part of our fundamental right. There are many cases, and particularly in the context of climate change and in the context of Paris Agreement and the Sustainable Development Goals and their targets, right to live in a healthy environment and to treat this right as a fundamental right, it is a great success, and we must compliment. We are leading in the world as far as this is concerned, or this interpretation is concerned. Right in this Shriram gas leakage, the court has pronounced MC Mehta versus Union of India is the name of the case, that right to live in healthy environment is a part of fundamental right. Otherwise, if you see, the slow poisoning is a much more dangerous than the instant death of the individual. Because if we are living in a polluted environment, we are dying daily with the slow poisoning, the slow death. Our all organs, they are being affected. Our lungs are being affected. Our heart is being affected. Our limbs are being affected. Our eyes, nose, ear, everything. And we die with a slow death. And therefore, the judiciary has traveled on the right wavelength to treat it as a fundamental right. Article 50 talks about a separation of executive from the judiciary. We must understand that there is no strict separation under the Constitution of India. In fact, separation of power is not a part of the Constitution. What we have followed in our Constitution is the system of checks and balances. But this system of checks and balances fail when we try to bypass the constitutional provisions. There are wonderful provisions in the Constitution which provide a safety valve in all situations, but we try to squeeze that safety valve, and we tinker with the intent of those constitutional provisions, and we take advantage by utilizing that safety valve to our benefit. For example, I give you one example of one political party. This is just coming to my mind. When Jayalalitha was declared not eligible to contest the election because she was convicted by the court for more than 2 years, and her appeal was pending in the Supreme Court, her party contested the election in Tamil Nadu, and that came with a landslide victory. Now, there is a provision in the Constitution that anybody could be made as a minister or a chief minister for the period of 6 months, even if he or she is not a member of the House, elected member of the House. And only within 6 months he or she has to be elected. So immediately after the election, though on one hand the Constitution and the court, they had prohibited that she is not eligible to contest the election, and she was made the chief minister of the state. It's another thing that within the period of 6 months, the judgment of the court came and her conviction was stayed and she became eligible. She contested the election and of course she won with the landslide victory. That is what happened in Bihar. When there was a campaign against, or when Lalu Prasad Yadav was convicted, he made his wife to contest the election and she became the prime minister. So what you cannot do directly, you are doing indirectly. That we have been taking advantage. That was never meant by the constitution. The constitutional safety valve was not for this purpose. Take the example in Delhi. There is a regular confrontation going on between the lieutenant governor on the one hand and the chief minister and his government on the other hand on the governance issue. Of course, the judiciary has helped to deliver by delivering a good judgment and bringing about the clarity on the constitutional limitations and constitutional provision. But in spite and despite that, that confrontational attitude between the executive and the elected representative, that should not be there. But unfortunately, we have not been able to travel beyond that. Secularism. The word secular does not mean that we have only permitted all the religions to exist. Secular, exactly in the constitutional sense, means when there is no religion of the nation. We do not say, and we cannot say so long we are secular, that India is a Hindu state. No, not at all. India is a secular state in which the Hindu religion, Muslim religion, Christian religion, all the religions, they have equal importance and equal place. It is our own choice. Whatever religion we wish to adopt or practice, we can practice. But nobody can force us to convert from one religion to another religion. Democratic. We say democratic, the simplest definition, government of the people, for the people, and by the people. I, as an individual, feel very hurt. I do not know whether you have ever seen in that sense or not. In most of the election, we are also having election now going on, and some held in Tamil Nadu. We just completed West Bengal. We are going on, and other states also like that. The political leaders, even the top political leaders, when they are addressing the people of the country in a democracy, they have the right. They are hardly talking about the issues of development, of securing social justice or securing economic justice. They are attacking the individual and the leaders of the opposite parties. I do not wish to take the names of any individual leader, political leader, but if you happen to be part of the political rally, or if you happen to listen on the television any political speeches or political rally speech of any political leader, then they are trying to woo the voters rather than educating those voters and telling them how we can achieve that fraternity, that social justice, that liberty, and that equality. Even some political parties, they indulge to the extent of misguiding or wooing the voters on the ground of religion. That was never the constitutional promise, but it has become a constitutional practice or a practice in this constitution. This is very, very disappointing. We, if are educated, our voters are very live, they are not ignorant, but many a time the uneducated voters or some of the voters who are moved by the religious tone in the political speeches, they sometimes get misguided or they go into the wrong direction. What is required to be the focus is the development of the local area, development of the nation, bringing equality and justice to the doors of each and every individual. We talk about a republic. Yes, We are true republic. There is nothing like inheritance in the governance. It's a different issue that some of the people may be talking about uh, the family politics, but in family politics, it is up to the people to elect those people. It is not without election that we can say who will be the next chief minister or who will be the next prime minister or the president, as the case may be. We are true Republican in character. We have now come to, I just come to those four pillars. We have justice. We talk about social justice, economic justice, and political justice. We have assured it. This was the promise to secure justice, social, economic, and political to all the citizens. But in practice, the social justice, I have discussed part of it. The economic justice, you know the reality yourself. And the political justice, it is yet to be secured by all the peoples equally. Liberty of thought, expression, belief, faith, worship, though these all are found, they are found not only in the preamble, but they are reflected truly in part 3 of the Constitution, particularly Article 19, read with Article 21 of the Constitution and 25 of the Constitution. We find they are there, but the fact of the matter is that they have yet to be secured in its true sense. We have seen the controversy about Sabrimala or Ram Mandir. Where is the, we have the freedom, or what is happening to the TV anchors, how they have to come to the court to secure a bail. The truth in the truth, or how many a time the media particularly, they have been publishing wrong reports. The media trial has become so famous in this country. It shatters the basic rights of the people. Similarly, the social media, sometimes how it affects the dignity of the individual when wrong news are circulated. Though we have enacted the laws, but that was never the constitutional promise. And we have failed in performance in ensuring the freedom of or the liberty of thought, expression, belief, faith, and the worship. The most important, where we have failed in the practice is the fraternity. We are no doubt a nation with the diversity. We have different culture which varies from state to state. As we travel from north to south or east to west, we find from movement from every state, we find there is a diversity. But unity and a diversity is a unique feature of our constitution. But in reality, when we see the fragmentation, not only between the states, but intra-state, that is the blow to the fraternity. We have to stand up together, ensuring the dignity of the individual and unity and integrity of the nation. Despite Article 17 being in Part 3 of the Constitution, where untouchability has been abolished, but we abolished only in the words. In true reality, there are some segments of people where untouchability is practiced by certain people of the forward community. The most important thing which has happened under the Constitution, if I have to carve out of the other developments, that in most of the cases, the judiciary has been able to establish itself as an independent organ of the state. And they have given very, very expensive interpretation to Article 21 of the Constitution, where large number of unenumerated rights have been interpreted as part of Article 21 of the Constitution, declaring them a fundamental rights. Like I discussed to you in brief, right to live in healthy environment was treated as a part of Article 21. Right to access to justice was treated as part of Article 21. Right to earn a livelihood was treated as a part of Article 21. If we have to see the entire constitution, we say the rule of law runs like a golden thread to the entire constitution of India. But in practice, we find the true equality, the substantial equality is yet to be achieved in the constitutional sense. Similarly, the absence of authoritarianism, the absence of arbitrariness as an integral, which is an integral component of the rule of law, that is yet to be seen in the true sense. In 76, we incorporated some fundamental duties. And the first fundamental duty, if we see, it is the most important. And if we just perform our first fundamental duty to respect the Constitution and its institution and the ideals enshrined in this institution, I think the rest of the things will automatically follow. The four pillars, they are strong enough. They provide a strong foundation to us to build a strong constitutional structure on these four pillars of justice, liberty, equality, and fraternity. And we should remember that we are to claim our rights. While claiming our rights, we are also required to keep in mind our fundamental duties, and we must perform our duties also. Then only we have the right to ask for our rights. With these words, I'll put a full stop to my lecture. I am online available right now if there are any questions by the participants.
Thanks a lot, sir. Yes, like sir said, we would like to have a couple of questions if there are any addressing the issue. Are there any questions? You can even post it in the chat box, or you can unmute yourself and ask, sir.
Any question?
No, sir, no question.
Well,
yes, sir.
Yes.
Hi, sir. Swapnil here. Good afternoon.
Very good afternoon.
Sir, as you have touched all the points which are very hot and really need to be considered being in line to the constitution, I still feel that the government, not only the politicians, but all the parties are more towards the ruling and revenue generation systems are more aligned towards that rather than focusing on the rights and the constitution. And the second thing, what we see is they are more aligning the people to be dependent rather than empowering them to come up and support themselves. So your views on this would be appreciated.
I have told you that the Constitution ensured and in fact talked about equality. Equality is substantial equality, not depending on anything. So that is what I said, that what is required to be done is the affirmative action. But unfortunately, our development in the political sense, they have not been in tune with the Constitution. That is my answer.
Yes, sir. Thank you, sir.
Any other question?
Okay. Yes. Any other question?
Sir, if I may be permitted to ask again,
Please.
and I have asked in the previous speaker as well.
Yeah.
Go ahead.
Sir, just because it's just a more of knowledge that you have just put into my kitty. And
Yes, what is the question? I can't hear you. Hello?
I think so, sir. The student has gone offline.
for my previous question, I would just like to ask you one question.
Yeah. Come, Giri, come, please.
Sir, Karl Marx had advocated for classless society Also in our part 4 directive principle of state policy, Article 44 talks about uniform civil code, which our the framers of the constitution, even Dr. Babasaheb Ambedkar advocated for uniform civil code. But with such a diversity, diversified culture of India, how is this just an idea to be debated upon, or that can be a reality in future in India? Sir, your views, please. If we take the present constitution to be implemented, and also whether the journey of this should be starting from the local self-government, that is the Panchayati Raj system in the rural areas, or is it the responsibility of the center and the state to implement?
A very good question. I did discuss when I was delivering a lecture on Article 44 also. If you go to Goa, do you find there only Parsis are there? Or do you find Hindus or Muslims or Christian all there?
So all of them.
All.
So this is just like a, in a cell you have small particles, or you have a nucleus, you have other DNA particles, everybody, and then there is a cell is there, right? Or if you talk about a structure, there your atom is there. Atom makes so many atoms join together to make a molecules, and then ultimately the structure is constructed. Similarly, we have different states, they all have a diversity. I never say, the problem is when we talk about uniform civil code, we say, oh, Hindu code. No, uniform civil code does not mean a Hindu code. Uniform civil code that you can have the best practices of all the religions, and then you can have a code. You can have you have a common criminal law or not? So
Yes,
you
sir.
have.
Yes.
So similarly, it is possible. Yes, this is to pass on the buck that it should start from the local level and panchayat level. This is all. I don't believe in that. The reservation for women, it started with the local level, panchayat level, and then legislature, municipality level. But why the legislature and parliament they do it? Nobody opposes it, but nobody brings the reservation for women.
Agreed, sir.
Any other question?
No further questions, I guess, sir.
Thank you so much. My
Yeah,
thanks
thanks
to
a
you,
lot,
and
sir.
thanks to Modern Law College, and thank you very much.
Yes, thanks a lot, sir, for being a part of this initiative and touching some very interesting and intriguing topics like reservation, equal pay for equal work, and definitely uniform civil code. Thanks a lot, sir, for this wonderful session, and we heartily thank you on the behalf of Modern Law College and our students. Thanks a lot, sir.
Thank you.
Thank you. And on this occasion, I would like to conclude that we are at the end of day 1 of the lecture series, that is Azaadika Amrutmahotsav. Now we would meet again tomorrow at 11 o'clock. The first lecture would start at 11 o'clock and it would go on till 1 o'clock like today. So bye till then, and we would all meet in tomorrow's lecture. Thanks a lot, and I would like to conclude the meeting for today. Thank you.